Hello there, my name is Stephanie Rojo, and I'm an attorney at Stone Law Offices in Las Vegas, Nevada. Today, I want to talk to you specifically about incapacity determination. When you establish your trust, you establish it to identify what's going to happen to your belongings when you pass away, but you also, within that document, have established a process for determining whether or not you are incapacitated and who's going to take over during that incapacity situation and how your assets are going to be used for your benefit. I want to key in about your document itself and what type of language you should be looking out for to understand the plan that you have in place within your trust document. So depending where you came from, depending on who crafted your trust, you may have a physician's opinion that says maybe one or two physicians are going to review you, conduct some tests to determine whether or not you have capacity to continue on as a trustee of your trust. For joint couples with joint trusts, you may have a private determination where your spouse and a physician together make that determination where you've been reviewed and analyzed to identify, okay, it doesn't make sense for you to move forward and serve as trustee any longer for a number of reasons. Maybe you've advanced in age and have memory challenges. Maybe you had some type of stroke that affects your ability to think clearly when it comes to financial decisions. Any number of medical or other reasons could come up preventing you from being a trustee. But the idea is we don't want anybody to just be able to come in and remove you from that position. We want it to be trusted advisors like physicians or a spouse and a physician. There's also something called a disability panel that might be included within your trust documents. And a disability panel is very similar. You are identifying folks that you feel confident are going to be able to make a good decision in determining whether or not you have capacity. Usually that's the person that you've identified as your healthcare agent and a physician. I've seen disability panels that have 2 or 3 folks on them. It's better to have at least one doctor, but you can definitely have a group of people on your disability panel that are not physicians at all. You could identify a collective group of people like your children or other family members or other trusted advisors. That's absolutely fine. But typically we do see 1 or 2 family folks or close friends and a physician serving. And the situation comes up where maybe your memory is starting to go, or you have another health concern that comes up, and your family is aware that you have a trust. Whoever is identified as trustee of your trust, your incapacity trustee, is either going to be reviewing your documents or talking to your attorney to understand what the next step is to remove you as trustee and put the incapacity trustee in place. And that is a delicate process because attorneys aren't going to want to move forward unless they have complete information, and they're going to want to talk to you as well as the incapacity trustee to get a better understanding of what's going on. And generally the next step is for the grantor of the trust or the creator of the trust, the person who's serving as the current trustee, to go talk to a doctor and to have an incapacity certification completed by the doctor. This is a certification that says you're either capable of moving forward or you're incapable of moving forward. It gives a snapshot for the attorney, for your incapacity trustee to understand that yes, indeed, you should be no longer serving in the role as trustee. Then if there is a disability panel, the folks named on that disability panel or your spouse would also fill out a document saying, yes, they are in agreement that this is the case, you should no longer serve as trustee. And then the next step is once all the check marks has been made for the requirements identified in your trust, then the incapacity trustee is going to be able to sign a certificate of incumbency, accepting the role as trustee, and it lays out the procedural history that you created the trust, any amendments were created, the terms of the trust identify that in a situation of incapacity, this incapacity trustee can step in. So it outlines what the situation is and who has the authority and the information that's in the trust that gives that person the authority. So it's a very formulaic process. It is involved in that the attorney needs to understand what's going on with you as the creator of the trust, needs to understand what the terms of your trust say, what your physicians or your disability panel in general are saying about your health, and then making sure that the incapacity trustee is willing and able to step up and serve. In some situations, that incapacity trustee is your spouse and they have no problem doing it. Sometimes it's someone else that you have identified within the documents. Ideally, you have 1 to 3 or even more folks identified as your incapacity trustee. So if the first person is unable or unwilling for whatever reason, you have some alternates in place. Worst case scenario, you may have language within your trust for the beneficiaries of the trust to nominate a trustee, or we may also be able to go to court and have a judge approve a trustee over the trust. If you or any of your family members have questions about incapacity trust, about the role of incapacity trustee, or what your particular documents say about how that incapacity trustee is going to come into play, please don't hesitate to reach out to me. I'm more than happy to review your documents for you and have a discussion about the incapacity trustee role. You're welcome to reach out to me at 702-998-0444. Again, my name is Stephanie Brohal. I'm an attorney at Stone Law Offices, and my number is 702-998-0444.